Welcome to the Gambone Law Podcast, brought to you by Gambone Law, a Philadelphia-based criminal defense law firm. This weekly podcast is based on questions that we have received from clients and their families. Our law firm is committed to providing the highest level of professional service through aggressive advocacy and serving as a trusted advisor during a tough situation. To learn more about our law firm, read my weekly blog, watch my videos, or download one of my strategy books, visit gambonelaw.com or call 215-755-9000 24 hours a day to schedule an appointment. This podcast is for information purposes only and does not establish an attorney-client relationship. Well, welcome again to the Gambone Law Podcast. My name is Alfonso Gambone. Every week we discuss criminal law issues. This week, I'm discussing an issue that involves not only criminal law, but in many cases, family law, and that's why I have it with me today, attorney Chris Casserly from the LaMonaca law firm in Media, Pennsylvania. Chris and I have worked together on some cases, and I wanted to have him here because, again, our law firm focuses on criminal defense, and we stay in that area. I found that clients need attorneys who focus on one area, and that's what they expect when they hire our law firm. When they come into our firm, they're expecting to speak with a criminal defense lawyer. That's what we do. If they have a family law issue, which PFAs, protections from abuse issues, involve, I'm going to reach out and contact Chris or Greg at the LaMonaca law firm in Media, because those guys know exactly what they're doing. So this week, I want to discuss protection from abuse, otherwise known as PFAs. And Chris, if you could just introduce yourself.
Sure. Yeah, absolutely, Al. Thanks for having me. My name is Chris Casserly. I'm a partner with LaMonaca Law based out of Media. Like Al said, we focus exclusively on family law issues. We don't try and delve into other aspects of the law. Instead, we trust professionals like Al to handle those parts of cases where our representation of a client ends and other matters begin, for example, criminal law. So super excited to be here today. PFA is great because if the law is a Venn diagram and you have criminal law and family law, the biggest cross-section of those two would definitely be issues of protection from abuse. By their definition, you're dealing with issues between people which in many instances do involve related criminal charges, which can sometimes frustrate the process, which we'll dive into today. But between representation on the family law side as well as where needed the criminal side, anybody who finds themselves subject to a PFA is going to be well represented between the two of our firms.
Great. Well, let's get to the first question. My ex-boyfriend with whom I have a child is harassing me. He comes to my job and leaves threatening notes on my car for me to call him. We have a court-ordered custody arrangement, but he doesn't even show up anymore as scheduled. He doesn't even care about our son. I've been told that I should get a PFA. Can you explain how I can do it and how long it will last? So Chris, why don't you take this one?
Sure, yeah. I mean, the thing that jumps out to me first is that this person's boyfriend was so kind as to leave a series of handwritten notes on her windshield, which is going to be huge for her in pursuing a protection from abuse. So when you do go in, the courts are looking for, in deciding whether or not to enter a protection from abuse, whether abuse occurred. And abuse can be a physical overt act, right? Me striking you and leaving a bruise, or it can be more of a course of conduct or pattern of behavior. And it seems like this person would be going through something that would fit more in that second box. So if you have somebody who's making threats of violence or leaving harassing notes on someone's windshield, that would certainly be something that the courts would look to, and based on the severity of those notes or how reasonable it would be for her to fear her safety in light of those notes, the court will enter a protection from abuse to make sure that her safety is preserved from this person.
Now, Chris, in a criminal courtroom, the burden of proof is on the Commonwealth, and that burden is guilt beyond reasonable doubt. And the Commonwealth, as you know, is represented by the assistant district attorney in the courtroom, and it's their burden. In a PFA situation, what is the burden of proof and who is it on?
So a lot of people, when they think about the law, they picture the scales, right? The scales of justice. And that's a really good way of illustrating how the burden of proof works in PFAs. So the standard is it's preponderance of the evidence would be the legal term, and it really just comes down to whose side is more credible, which side weighs more, right? So which side of those scales has more weight on it, and that's really what you're up against. It's almost equal footing, whether you're the plaintiff or the defendant. You do have to prove your case proactively. So it's not like criminal where you can go in and say, prove it. You actually have to proactively assert your defense to any charges or accusations that are made as part of a PFA.
So it's a civil action.
Definitely. By design, it's a civil action.
And I think that's important because you have to understand that if you have a situation where you receive notice that a PFA has been filed against you, and I know Chris just spoke about the burden of proof and who it's on, I want to speak a little bit about PFAs from the defense side. If something's filed against you in a civil action, it can also be filed against you on the criminal side through the Commonwealth or the state. So you could have, in many situations, a PFA action and also a criminal action, correct?
Absolutely. Mm-hmm.
And it's important for our listeners to understand that in a PFA situation, the standard of proof is much lower. In a criminal action, it's much higher. In a criminal action where there's also potentially an active PFA case, some of the charges that you probably would face would be simple assault, aggravated assault, terroristic threats. Those are very common. Possession of instrument of crime. These are all very common actions that are law firm defense, and I think it's important to understand that. Now, in a criminal world, if a person's convicted, they receive a sentence. A sentence could be a probation, it could be jail. In a PFA action, if a person's successful, how long does it last?
Right, so if the court finds that PFA is warranted, in Pennsylvania, the longest protection from abuse order that you can get would be for a period of 3 years. And they can go up to that, depending on the severity of the allegations. If proven, it'll be the full 3 years. Sometimes you'll see one where it'll be 1 year, and then we'll come back and revisit it. And then at the end of those 3 years, if really nothing has happened, it's unlikely that the court would extend that PFA. But if there's instances of violating that protective order that occur over the course of the 3 years, or even just unrelated criminal acts, then you are looking at a possible extension of that 3-year period. So 3 years would be the succinct answer, and like with anything in the law, that's subject to change.
And just to follow up on that, with regards to the actual PFA, if it is put into place, in this situation, we have a situation where the ex-boyfriend is leaving notes on the car. Mm-hmm. How close can this person now get if a PFA order is ordered?
Yeah, so I mean, there's no statutory radius, right? Like an imaginary line around the person. You can't go within this. But what they'll typically exclude the person from being around would be that the petitioner's place of business, their home, and in instances where the PFA involves children as a protected party, those children's school, if they do gymnastics, the gym, anywhere where they would typically be found, the person who's subject to the PFA would be in violation of that if they should ever step foot on those premises.
Okay. So let's go to the next question. How will PFA affect child custody? Why don't you take that one?
Yeah. So with the PFA, we touched on a little bit whether or not the children are listed as protected parties. So a person who files for a PFA, one of the first things that they're going to include in their petition is who they want that order to protect. It'll typically be the petitioner themselves, but in some cases they'll also have the children listed as protected parties. These would be in instances where the defendant's conduct in some way compromised the health and safety of these children. In those cases, the PFA will prohibit them from having contact with the children who are subject to the action, but the PFA statute expressly provides that can be overridden by a subsequent custody order. So if you find yourself in a position where you have a protection from abuse restricting your access to your children, you still can file in custody to go open that up, and the courts will try and find something to balance the order restricting your access from the children or making sure that you can't put them in harm's way with you being able to still have some sort of contact with them, whether that's FaceTime, Skype, or more of a supervised face-to-face custodial action. So it definitely will prejudice you in custody to have a PFA prohibiting you from contacting your children, but that's not to say all is lost. You do have other avenues to try and open that up and preserve your relationship with your kids.
Okay. Now, we're speaking about custody and also PFA hearings. Both of them would require sworn testimony in court, right?
Fair.
Okay. So in these situations, I kind of want to bring criminal in here a little bit. You have to understand that if you're in a situation where you're facing criminal charges or potentially facing criminal charges, you need to be mindful that you're walking into a courtroom and you may be called to testify. You don't have a Fifth Amendment right in a civil courtroom, but you have the right to take the Fifth Amendment if you believe that you're going to incriminate yourself by making a statement that does that. So I would stress that the fact that you're in family court, which is where these actions would occur, you have to keep in mind that you are making a sworn statement, and that the Commonwealth, if they wanted to, could order the notes of testimony and potentially use those at trial or even a preliminary hearing in Pennsylvania. Because again, it isn't hearsay. It's a party admission potentially, and two, it's a statement made during court proceeding. It's a sworn statement. So I would imagine that from my standpoint, if I was advising a client, I'd be very concerned about a client testifying at a PFA. I don't know if necessarily I would tell them not to testify at all, but I would definitely be there and want to know potentially what they were going to say, especially if they were already facing criminal charges or I knew that criminal charges were coming down.
Yeah, and that's one thing that from a family law perspective, we often have to educate our clients where they do find themselves subject to a PFA based on a set of circumstances that have also given rise to criminal charges. I won't say under no circumstances because there's never absolutes, but 9 times out of 10 now, we're telling people that I know you're chomping at the bit to go defend these accusations, both criminally and in the PFA court. But like we said before, in PFA, it's preponderance of the evidence. You have to proactively assert your defense, and oftentimes that includes offering testimony as to where you were that day. Those people would be putting themselves in a very precarious situation, and their criminal attorney will be very upset with me if I put them on the stand or if the other side puts them on the stand. And they run the risk of not only having the PFA entered against them because they're not going to offer any substantive testimony in defense of it, but also prejudicing their criminal case. And that's something that we try and avoid wherever possible.
That's a good point. Let's get to the next question. Okay, this is something we've already touched on. Is an abuse allegation made within a PFA the same as a criminal charge? I'm going to take this question. We just spoke about this. In both situations, an allegation is made. But it's important to understand that the burden of proof is different for those allegations. So in the PFA situation, the protection from abuse hearing that determines whether or not an order is put in place, the burden there is on the petitioner, who is the person filing the PFA. In the criminal courtroom, the burden is on the Commonwealth, and that is in the form of the district attorney who's prosecuting that case. The allegation, and I'll use some examples here that I deal with in my practice. Simple assault, aggravated assault. Again, we're looking at physical contact with an intent to cause or an attempt to cause bodily or serious bodily injury. Again, I think Chris would agree with me that a simple assault would be the type of action that would create the good possibility that a court would order a PFA.
Right, and that's where you find yourself in a situation where simple assault or something that's more like a harassment or some of these lesser charges. Those are the cases where you do weigh whether or not you want to proceed on the PFA, because the downside that you're looking at on the criminal side of things isn't great. I mean, that's, I guess, assuming a lot of variables like no priors, but it's when you get into those more serious charges, those misdemeanor charges, that we really do get to the point where absolutely not. You're not going to be trying that PFA before the criminal one.
Right. Mm-hmm. Now, Chris just mentioned a misdemeanor charge. You have to understand that in an assault situation, assault can be a misdemeanor or a felony in Pennsylvania or New Jersey. It's very important to understand that if you're charged with a felony, there's almost a presumption that you could face some jail time, whereas a misdemeanor, jail time's likely, but if it is jail time, you're looking at more of a county sentence. But in many situations, it's a probation sentence. With regards to a felony charge, though, much more serious. And all these topics, simple assault, aggravated assault, terroristic threats, are all on my website, through my blog, gambonelaw.com. I have a lot of resources there. And Chris also, through his law firm, all these issues that we're speaking about right now. Chris, why don't you tell everyone your website that they can go to learn more about issues like PFA, defense, and also other family law issues?
I'd love to. Thanks, Al. So our website, LaMonacaLaw.com, you'll find under the blog section articles written by our attorneys that address the vast array of family law issues that clients often find themselves Googling in the middle of the night. So what we really try to do with the content that we post on our website, as well as to our Facebook page, is address those questions that have people like pining for answers, not able to sleep at night. And those things often do include PFAs. They very much include custody, right? What's more important than your kids? They'll include things like how to distribute or divvy up a business as part of a divorce when both parties have developed the business over the course of the marriage. So we really do try and focus in on that balance between those day-to-day issues that clients face, but also the more dry stuff, the more statute and law-based things that are what we take into court and present our client's case based on. Okay. So yeah, you can find those on LaMonacaLaw.com. And the best way to really stay up to date on all the content that we're putting out there would be to follow our social.
Okay. Let's take two more questions. Next question. What happens if I'm served with a PFA petition and I ignore it?
That's not going to go well for you.
Okay. So why don't you kind of explain what could happen?
Well, the big thing is, you have the right to a hearing on the allegations under the PFA to occur within 7 to 10 days. That's not always going to be what's best for you. So, for example, if there's a dispute over a custodial exchange that occurred in a Wawa parking lot, right, and there's cameras everywhere, you can go in there and say, I absolutely did not make a threat to this person or gesture that I was going to hurt them or anything like that, and it would be your word against theirs. And you can have that hearing within 7 to 10 days. That's your right. But the better move would be to wait, push out that hearing date and subpoena the records from the Wawa videotape so that you can go in. Remember, preponderance of the evidence. The videotape's going to be dispositive in that situation, almost certainly. So although you are entitled to a hearing once you receive notice within 7 to 10 days, you may want to talk with an attorney about whether it will be better for you to take that temporary PFA order that'll impose certain restrictions on you in the short term, in favor of collecting the evidence that you're going to need to really set the records straight and prove your innocence. If you don't show up for a PFA hearing, you might get lucky and the judge will say, all right, I have some questions about whether or not there was good service on this person. Come back next week and we'll have the hearing. But if you are just not opening your mail and the police are able to provide corroboration that they did serve you, at some point, if you don't assert a defense to the allegations, they will enter an order against you. And you will have had several opportunities to defend against that.
And again, that order will last 3 years.
At the most, yeah.
Okay.
Yeah, and then could be extended thereafter if certain things occur over the course of those 3 years.
Now, I know that in the criminal world, if you don't show up for a hearing, there's potentially a possibility for a bench warrant. And it happens in many cases. Now, there are some situations where our clients do forget to come to court. Obviously, that happens despite reminding people to come to court. Things get busy and people make a mistake. If an attorney is there typically and they have a good relationship with the prosecutor or the judge, they will typically allow the attorney to accept service. In the PFA situation, if you don't come to court, have you been experienced with judges who do enter a bench warrant?
So with the PFA, typically you won't see something so drastic occur. I mean, they will enter the order, and I guess that is drastic. You can't contact this person for 3 years, but they wouldn't issue a bench warrant, to incarcerate you pending a hearing. That's with regard to the underlying PFA itself. Now, as part of PFA, you have issues of indirect criminal contempt. So this would be in an instance where a person violates the PFA. That is, they have contact with the person, which can be a butt dial, or it can be, texting somebody. It could be showing up at their work, like we talked about. And if that happens, whereby the DA brings indirect criminal contempt charges against you, if you no-show that hearing, there's a good chance that you'll have a bench warrant issued.
Okay. All right. Last question. Will PFA affect my ability to carry or even possess a handgun? I'm going to start off here. Yes, there are situations in Pennsylvania and New Jersey where I've represented persons who have a PFA ordered against them, and they're charged with carrying or possessing a handgun, and it's a crime. Now, normally in Pennsylvania, you don't. Well, just let me stop right there. Normally in Pennsylvania, unlike New Jersey, you don't need a permit to purchase a handgun or possess it, whereas in New Jersey, law is much different. You have to obtain a permit to even buy a handgun. But if the handgun is in your home, you don't need a special license for it in Pennsylvania. New Jersey, again, is different. In the case of a PFA, if an order is entered against you, it's a crime even to have it. So you can't have it in your home or place of business. Now, normally, possession of a handgun by a prohibited person is a felony. But if you have nothing else in your criminal background other than this PFA, which isn't even criminal, the 6105 charge, which is the possession of a gun by a prohibited person, would be graded as a misdemeanor, not a felony. And that's an important distinction. But with regards to the actual charge, it's important to understand that if you are driving in your car and you have a gun underneath the seat, you will be charged with possession of the handgun by a prohibited person, also possession of a handgun, potentially carrying a gun without a license if you don't have a concealed carry permit. Those are very serious charges. Obviously, the felony charge is more serious, but you have to understand that, again, if you have a PFA order against you, you keep that in mind that you cannot possess a handgun. And I think, if I'm correct, if an order is entered against you, Chris, you have a certain amount of time to relinquish all of your firearms. Is that correct?
That is correct. Yeah, so we've been talking a lot about the 3-year PFAs, but before the 3-year PFA gets entered, there's going to be a temporary PFA entered, and that's really based on one person going in front of a judge or a magistrate and saying this is something that happened. And remember, you're entitled to a hearing within 7 to 10 days, so that decision maker is going to err on the side of caution and probably enter a temporary order based on the testimony they hear. As soon as that happens, you do have an affirmative duty to relinquish your firearms, and in most instances, when the police come to serve you with a copy of the PFA, they'll simultaneously conduct an inventory of the firearms and ammunition that you have in your house, and you'll surrender that. It's inventoried. It'll be held at the police barracks. And if you're successful in defending against the PFA, whereby it's dismissed, then you will be able to get back your guns. The same goes for anybody else that's in your house, right? So if you're living with your brother and he's goes to mass twice a day, straight A student, all around good person, and has a licensed firearm, if you are served with a PFA and you live with your brother, it doesn't matter how squeaky clean he is. He's an adult household member. He will have to relinquish his firearms as well. And you could be subject to criminal charges for his failure to do so. Okay. Another thing to bear in mind is that when you do go into court for a PFA, there's a lot of times where attorneys work out a deal, right? So I'm looking at a 3-year PFA being entered against my client. Maybe we talk about an 18-month, and we'll do that by agreement, right? and sometimes that's favorable to the client. But if you do enter into an order under the PFA docket where it is, an extended PFA order entered against you, even where it's done by agreement, that will restrict your access to firearms for the duration of the PFA and thereafter. So something to bear in mind.
Okay, well, that's great. So I just want to close by saying Chris mentioned a point that if police come to your home, it's very important to understand that if you're confronted by police, you want to be cooperative, but you don't want to give consent to search your person or your property or your car. Cooperative in the sense that you provide your name, your license if it's a traffic stop, but never give consent to search anything. I talked about that in previous podcasts. Again, all these topics, illegal search and seizure, things like defense of guns, drugs, drunk driving are all discussed not only in the podcast, but on the website, gambonelaw.com. To schedule an appointment in the office, just call 215-755-9000. Chris, why don't you give out your contact information?
Sure, yeah. For any issues relating to family law, PFA, custody, support, divorce generally, give us a call, 610-892-3877. Or if you go onto our website, we have people waiting to chat with you live and through the website portal, and you can do that at www.lamonacalaw.com, as well as on Facebook. Just search LaMonaca Law.
Great. Well, Chris, I want to thank you for coming on. This is podcast number 9, and we will see you all next week. Thank you.
Thanks, Al.
Thank you. Cool, man. See you.